I'm Barry Marks with Marks & Associates, and I'd like to share with you some of what I've learned over the years representing banks, equipment lenders, and equipment leasing companies. You know, one of the most common things that lessee counsel, including counsel that is not familiar with equipment leasing, likely to say about your lease is that he or she wants a grace period for a default. For example, 5 days after notice if the rent is not paid on time. 30 days right to cure in the event there's another type of default. These things sound perfectly reasonable, but keep a couple of things in mind. First, if you allow a lessee 5 days across the board grace period for paying rent, that's basically meaning that that rent could come in every single time 5 days late. What does that do to the economics of your deal? What if it's 10 days or 5 business days? Secondly, we do not advise agreeing to give notice of failure to pay. That brings about a couple of problems. First of all, if the lessee receives notice that it hasn't paid its lease and that you're going to demand the payment be made within the next 5 days, that lessee has 5 days to file bankruptcy. And as we'll discuss in another of these videos, there's a world of difference between having a default called before the lessee bankruptcy and afterwards. Second, in the real world, these days many leases are paid by electronic funds transfers, ACH. The days of paying by check are maybe not over, but they're certainly the exception rather than the rule. Why does the lessee really need that notice? What we recommend is the lessee should have 1 grace period per year, 1 grace period per 6 months, 3 to 5 days. That way, if there's something bad happens, the lessee has the opportunity to cure, and you're not likely to be calling a default on a good lessee for a couple of days late rent anyway. But don't give the lessee the right to do it every single month. And as for that 30-day grace to cure other defaults, lessee counsel is going to say, well, you're telling me that if I fail to give you a certificate on time, you're going to roll up the lease? No. But that 30-day grace may be perfectly reasonable in some situations, but not in others, such as, what if the lessee doesn't carry insurance? What if you receive notice that the insurance policy has actually lapsed? And remember, your insurance policy, if it's properly drafted, is going to give you advance notice before the insurance is actually canceled. What happens if the lessee tries to sell your equipment? What happens if the lessee fails to return your equipment? Do you have to give 30 days notice that the lessee didn't return the equipment as it was supposed to? There should be some exceptions to any of these types of grace periods. For more information about defaults, visit us at www.leaselawyer.com.